Warning: the following information is based upon evidence collected by criminal investigators, whistleblowers, and constitution-loving Americans. This video answers questions asked by average Americans like you. The information is factual. The evidence is validated. Viewer discretion is advised.
Okay, you've heard all the warnings. You ready to learn? Here we go. Hey, this is not going to be a short video, so if you got the attention span of a gnat, well, go someplace else. Now we're going to talk about audits. We're going to be talking about the audit. When you look at this, both Pennsylvania and Arizona are talking and hyping up the audit. The audit in Arizona has been going along for about 6 weeks or so, and I've been telling people this for 6-8 weeks. The audits mean nothing. Absolutely nothing. And here's why. The United States Congress has the authority and power to change the way that its elections are handled. And so right here in the Constitution. But the Help America Vote Act is really important here for us to understand what's going on with the audits, because the spending clause gives the Congress the ability under the General Welfare Clause, the spending clause, to enact law, and it did so in 2002. 18 years later, all the states have been taking money under this Help America Vote Act. And when you look at this, the Supreme Court's already affirmed the Congress's power to impose such regulations tied to federal grants serving general welfare. South Dakota via Dole 1987 was a determining factor to that. The court since that time has focused on the evaluating conditions of the federal spending statutes placed on state governments. Now, the court has required that the federal government make its conditions clear at the time that state accepts the grant. And the states accept grants every year. And the conditions are very, very clear. That was Arlington Central School District v. Murphy in 2006. Now, as long as the conditions are clear, simple. Here's the Help America Vote Act of 2002, which mandates use of payment general. A state shall use the funds provided under a payment made under this section to carry out one or more of the following activities, complying with the requirements under Title III. Title III, very, very important. We've been talking about it. We're going to continue to talk about it. We're talking about it right now, and this is why every audit is fraudulent. Every audit is fraudulent. It's a scheme. It's a way to put malaise over your eyes and drag out the time and just get you to basically accept everything as being hunky-dory, and it's not. Because 303 states very, very specifically here, the audit capacity in general. The voting system shall produce a record with an audit capacity for such system. It's talking about what the system does, not the ballots, not the vote, but the system. What the system does. And what the machine record is then the official record. So you've got B3, which is the vote and the ballot. But 2A is the condition of the system. This means the machine must create a record of what the machine is doing, not only the count of the vote, and those records must be maintained. Those records for the machines and the ballots must be printed, maintained for 22 months as part of the election process. Now, this is very, very important to understand, because when we look at the Arizona law, well, the Arizona law is saying very specifically in Title 16, Chapter 4, Article 4, Arizona Law 16-449, it states that this is the procedure, but we're looking at 1662 for what is actually maintained. And it says right here, the officer in charge of elections shall ensure the electronic data from and electronic or digital images of ballots are protected from physical and electronic access, including unauthorized copying or transfer, and that all security measures are at least as protective as those prescribed for paper ballots. Now, that law is very interestingly worded, because it seems to, on the first one, only talk about the digital image of the ballots, but it says electronic data from and electronic or digital images of ballots shall produce a record of the audit capacity of such system. Not only the ballot. Not only the ballot, but also the system itself. Now, go in here at Pennsylvania. Pennsylvania's record is found in the County Records Manual. As you see, it was updated in 2017. But you're looking at the additional retention requirements. Currently, federal election records, including all records and papers pertaining to any application and registration or other act records to voting, must be retained for 22 months. Notice it says currently federal election records. Records. Now, people are going to say, well, I only thought I had to maintain the ballots. No. Section 301 of HAVA is very specific that it must maintain a record of the system as well. Go back up here to this again. Section 301, which is in Title III, produce a record of the capacity of the system. Now, everyone was beating on Dominion pretty hard, and both Pennsylvania and Arizona both use Dominion systems. So let's look at Dominion systems. The Dominion manual, as used by both Arizona and Pennsylvania, and if you listened, also by Michigan, the ImageCast remote audit log records all administrative accesses. Now, this is how ballot box stuffing is done, is through the administrative process. They're either shoving more ballots into the system they're registered for voting, or they're coming in and putting them into the machine and saying, well, this is a recount, and this is a re-edit, and this is a cured ballot. And this is the matter the ballot box stuffing has gone on. Now, remember, when we were talking about Michigan, and we were talking yesterday about Wayne County in 2016, 37% more people voted in Wayne County than were actually registered in 2016, and more people voted once again in Wayne County. Now, this is really important that you're looking at these Title III violations, because you look at Title III violations, every state, going to say it again, every state, including Arizona and Pennsylvania, violated Section 303. Now, I want you to count these. Each time I talk about this is a violation of Title III. Failure to match state identification list to Social Security Administration database is required. 1. Failure to administer interstate voting registration system is required. 2. That's to find out if somebody's registered in another state. 3. Failure to obtain voter registration information. Now, here we go. 4. Failure to obtain information if voter registered in another state. 5, failure to ask if registrant has voted in a federal election before, and that's before they get a ballot. That's part of the registration process. You need an identification. There's no identification's not on here, but identification is also required. Arizona and Pennsylvania had non-compliant without identification laws. So we're already at 6. 7, failure to registration by mail violations. Failure to obtain first-time federal voter status. That's got to be handled with the ballot as well as an identification. Failure to confirm voter has not registered or not voted in the current election in another state before they get a mail-in ballot. Now, we're looking at people moved into Nevada and Arizona from California. They voted in California, then came in Nevada and Arizona and voted again. That's very important in the Arizona ballot. Very, very important, because it's multiple ballots. Now, failure to confirm voter is not registered in election in another state. That's a big issue. Failure to process required information before issuance of a mail-in ballot. Now, that's the state failed to do all of this prior to issuing a mail-in ballot. And proper mail-in voter and registration forms. There's 10? We're at 10, and we look at Section 304, failure to meet the minimum requirements of Title III. These are very, very, very serious issues here, because you cannot confirm who won, because you can't confirm how many ballots were actually lawfully issued and actually lawfully registered. How many voters were lawfully registered? When you can't match the number of votes to the register and you can't match the person to the ballot, that's a violation of HAVA. Now, when the machines themselves do not have the registration logs, that's a non-auditable election, a violation of Title III. Now, I would state that every Secretary of State and every election official that entered into a contract with the Dominion or EASS, knowing they were not going to get the capability of getting those logs, entered into a fraudulent contract, and they did so illegally. Now, when you do that, you're looking at false claims before the federal government. The False Claims Act is 31 U.S.C. 3729 through 3733, and Department of Justice is it's a civil action, but you have criminal consequences of those civil actions. Now we go back to the second look at these issues here. Not only do you have to use the money, but in C, you have to use the funds and state a certification that those funds are going to be used legally. Now, every Secretary of State, every governor, every election official, everybody who placed a certification to the federal government engaged in federal fraud. These are criminal statutes. Now, these statutes are pretty straightforward. 18 U.S.C. 1001, false statements. That includes not only the certification of that you're going to use the money, but it's also certification of the election itself. The congressional ballot, whether it's for the House or the Senate, it's fraudulent because you can't tell how many people are supposed to vote. You didn't secure the election process. When you look at the presidential ballot, it's the same thing. You didn't secure the election process. You used federal monies fraudulently, and then you made a false statement to the federal government. Now, making that false claim that the election was legal was a violation of 18 U.S.C. 287, stating the election was done legal. It wasn't. Every congressman in Congress from Pennsylvania and Michigan and Arizona, as we've discussed in these videos so far, are unlawfully seated. California is the same way, by the way. Factually, spoiler alert, only 5 states did the process sufficient enough to be able to say that it was legal. Now, conspiracy of the state senates, governors, secretaries, and so forth, secretaries of state and so forth, and members of political parties. 18 U.S.C. 371, conspiracy to defraud the federal government. Conspiracy to defraud the government. You know you're using taxpayers' monies illegally as part of your two-party duopoly. You know you're doing it, and you're doing it. That's a fraud statute. Now, specifically, 18 U.S.C. 644 prohibits a person from applying money for any purpose not prescribed by law. So anytime a state took money and they didn't do it in the way that they're supposed to do in Title III, well, that's a criminal violation of 644. Anybody who dispersed that money, anybody who accepted those monies. Now it gets to 18 U.S.C. 648. This forbids custodians of public monies from loaning, using, converting those funds, or depositing or exchanging them, except as authorized by law. Now, when you look at this, you're only able to use the money as allowed in Title III. Any other use other than that is illegal. And they're going to say, I can buy a machine because it's legal, but you didn't use the system, you didn't use the machine properly. And that's the second step of the use of funds. Because you're buying the machines and the systems, but you have to keep the papers and records for them also. And it's that very, very important section on page 38 of the Dominion Manual. It's very important. All 45 states we're going to be covering fraud. Georgia, you're there too. Now, these are the federal criminal statutes, but the state statutes have some pretty significant teeth as well. In Arizona, tampering with public record and classification is a misdemeanor or a felony. That's any person commits tampering with public record if with the intent to defraud or deceive such persons knowingly. So if you knowingly certified the election knowing you weren't in compliance, and how can you not know you're in compliance? You're supposed to have the records. It's crystal clear. In 201, 301, 303, 304. Very simple. I ask you people this. When you went to vote, whether in person or in mail, did anybody ask you, is this the first time you voted in a federal election? And if you answer that question, no, your state committed fraud. Grant fraud. That simple. It cannot be any simpler. When you look at Pennsylvania, Pennsylvania has the same law on the books. Different statute code, of course, tampering with public records. So anybody who's going to turn out and accept an audit and say, hey, this is lawful, that's tampering with public record. Anybody who's not going to do anything other than turn around and say, hey, we're going to hold you guys accountable for the fraud you committed by improperly designing the system to engage in ballot box stuffing. We're coming after you. It's time to clean up the business of politics.